Hello students and welcome to the next session of company law. In the last session we talked about the key managerial personnel role in the company, the appointment of the key managerial personnel, MD of the company, then manager of the company and the regulations, provisions relating to the managerial remuneration of the company. Now we'll take it further and we will try to understand the today's topic. The topic name is inspection, inquiry and investigation. So what is the name of the today's topic? Inspection, inquiry and investigation. Inspection, inquiry and investigation. So in today's topic we will talk about the provisions from section number 206 to 229. So provisions relating to inspection, inquiry and investigations are given under section 206 to 229. Not all sections we are going to study in detail, but the important sections relating to the inspection, inquiry and investigation of the company we will try to understand. So it has become very imperative for the central government to assume certain powers to investigate into the affairs of the company in certain appropriate cases. So the reasons is particularly when there is reason to believe that the business of the company is conducted with the intent to defraud the creditors of the company or members of the company, or maybe for some fraudulent purposes or unlawful purpose, as the case may be. So in this particular provisions, chapter number 14 of the Companies Act 2013, section number 206 to 229, there are provisions with respect to inspection, inquiry and investigation into affairs of the company. So let's get started with the first provision of section number 206, which talks about power to call for information, inspect the books of account. So first the inspection will take place, then the inquiry and the investigation. So we will try to understand that particular flow in this particular chapter. So how it's going to be done? So there will be inspection in various provisions, then inquiry will take place, and then finally there will be investigation. So we are going to talk about various authorities, investigative authorities, in this particular chapter. So let's try to understand the first section, that is power to call for information, inspect. So this particular section, as you can see, is for the inspection, books and then conduct inquiries. So first you inspect the books and then you may conduct various inquiries. So this is the section number 206. Inspect books and conduct inquiries. So under 206, the powers are given to call for information, to inspect the books and conduct then inquiries accordingly. So there are various provisions in this particular section. So there is the power given to the various authorities, like we have the registrars of the company. The registrar may call for the information. It may ask to submit documents to the register of companies, and then directors and employees are supposed to give such kind of information. So first power is given to power of the registrar to call for information, explanation or documents. Let me just put the pointers. Duty of company and its officers, past officers, additional by registrar, then inquiring by the registrar, inspection by CG, and the last part is failure. So we'll just talk about the penalty part in the next page, on the next page. Failure to furnish information. So there will be penalty. We'll talk about that as well. Okay, so this particular 206 section is divided into these various parts. So first of all, the registrar will have powers under section 206 subsection 1 to call for information. 206 subsection 1, he may call for some information. So where on scrutiny of any document filed by the company, so various documents which are supposed to be filed by the company, or any information received by him, the registrar is of the opinion that any further explanation or the information is required from the company's side, so he may send a written notice calling for this information. So he may ask to produce the documents or kind of information explanation within the reasonable time as we specified. So no time limit is given, so he may decide the reasonable time, like it is 7 days, 15 days or 30 days as the case may be. After that, okay, after calling the information, it will go to the duty. Then what is the duty of the company and its officer, including the past officers of the company? Okay, so this particular provision is given under section 206(2). Which says that on receipt of the notice, so once the notice is received by the company or its officers, okay, then the company and its officers should furnish the information or the explanation to the best of their knowledge, whatever the records are available with the company, okay, within the time specified in the notice. Now it may so happen the information was available with the past officer who is not working with the company. So where such information relates to the past records, the officers who had been in employment that time, okay, if so called upon by the registrar, if the registrar has given notice to the past officer, then he may be, okay, asked to provide the information as per his best knowledge. Then additional written notice by the registrar, okay. So if registrar is not satisfied by the details given, so he may send an additional written notice as well. So the powers are given to the registrar, so he may buy another written notice again, okay, on the company to produce his inspection. So such further books of account, books and papers, explanation, okay, he may require. So if the information has to be provided, and at such time he may specify in the notice if no information or explanation is furnished to the registrar within timeline. If the registrar on the examination of the documents furnishes of the opinion that the information or explanation is inadequate in nature, okay, and if after the scrutinization of the document, okay, there are unsatisfactory state of affairs exists in the company, if the registrar is of that opinion, he may call for some additional information. But registrar will have to write down the reasons for asking for the additional information, and then the inquiry by the registrar will take place under section 206 subsection 4. So inquiry. Okay, so registrar may call on the company to furnish in writing any information or additional information as the case may be, by giving the reasonable opportunity of being heard. And if registrar is satisfied that on the basis of information available or furnished, or on a representation made to him that the business of the company is being carried on for some fraudulent or the unlawful purposes, and if it is not in compliance with the Companies Act and the rules made thereunder, and grievances of investors are not being addressed properly. Okay, so in all these cases the registrar has to inform the company of the allegations made against him in the written order. The CG may, if it is satisfied that circumstances so warrant that inquiry is required, then inquiry may be conducted. Okay, so CG may direct, okay, registrar or the inspector to conduct the inquiry. So here you can say that CG may direct to conduct inquiry. And he shall be punishable with fraud provisions. Then the inspection of the CG may take place. Okay, central government, okay, in spite of having all these powers, but in addition to that, central government, if it is satisfied that circumstances so warrant, direct inspection of the books of accounts or papers of the company by any inspector appointed by him for that purpose. So central government may appoint, okay, will have powers to appoint inspector to have the inspection of the books of accounts or papers or any documentary evidences. And of course after that, if any particular company fails to provide the information, then what will happen? Failure to provide the information, okay, so there will be penalty for that matter, okay, which is given under section 206(7). What does it mean? Which kind of penalty will be there? If the company fails to furnish any information, then the company, every officer of the company who is in default, okay, then what will happen? A company and every officer of the company and of company who is in default, जो default में है, okay, with fine, so there will be fine, which may extend to rupees 1 lakh, okay, plus rupees 500 for every of default. Continues. Okay, so this type of fine can be there. So this was section number 207, where we have talked about the power of the registrar to call for the information, what will be the duties of the company and its officers. Additional, okay, powers are given to registrar to call the information. Inquiry may be conducted by the registrar. CG may direct to conduct that inquiry, and even the inspection powers are directly given to the central government. Now we will talk about section number 207, conduct of inspection and inquiry. Conduct of inspection and inquiry 207. So here also there are sub points. Okay, one by one we'll try to understand. So duty of director and officer. So first of all, what is the duty of director and officer? It is given duty of director, officer or employee. Then powers of registrar or inspector. And penalty for contravention. Okay, so these are the provisions given under section 207. So subsection 1 of 207 talks about what will be the duties of, okay, employee, director and officers of the company. So where a registrar or the inspector calls for the books of account, other books under section 206, it shall be the duty of every officer or of director or employee of the company to produce all such information to the registrar or inspector, to furnish statements and the information as may be called by the registrar or inspector, or to render all the assistance, okay, to render all the assistance to the registrar or inspector. And what will be the powers of registrar or inspector? So registrar or inspector making the inspection under 206 may during the course of inspection or inquiry make or cause to be made copies of the books of account. They may place or cause to be placed any marks of identification on the books of account, so they can take into custody and they can put the marks on that. And registrar or inspector making an inspection will have all the powers of the CPC. Okay, so they will be given all the powers of the CPC also, okay, for conducting the inquiry and inspection. So which all powers will be required, like discovery and production of any document, production of books of account, other documents at such place and time as may be specified by them. Then they may summon or they may enforce the attendance of any persons and examine them on the oath. They may inspect any books of accounts or register or documents of the company at any such place. So all these powers will be given to the registrar and inspector. And if the officer, employee or director is not helping them out, then there will be penalty for that. Section number 207 subsection 4. So what will be the penalty? So here I can say that all I can say civil court powers as per CPC 1908. Okay, so penalty: if any director, officer or company disobeys the direction issued by the registrar or the inspector, then such person shall be punishment with imprisonment. So there can be penalty, punishment of imprisonment and with fine. Okay, so what can be the imprisonment for that matter, and with fine up to 1 year, and here 25,000 to rupees 1 lakh. Okay. So if the director or officer has been convicted of an offense under this section, then they on or from the date of that he is so convicted will be deemed to have vacated the office. So vacation of the office will also be one of the penalty for such director or officer. So we have so far seen two sections. Okay, then there are some other sections also. After doing that, okay, the registrar or the inspector will prepare the report. So report on inspection made. Report on inspection made. Section 208. So this particular section talks about for submission of the report on inspection made. So registrar or inspector after conducting the inspection will prepare a report, and it will submit a report in writing to the central government along with such documents, if any, and such report may if necessary include recommendation that further investigation into the affairs of the company is necessary, giving the reasons in support. So what will happen? Okay, registrar and inspector after the inspection, so you can say registrar or inspector after inspection submit report in writing to CG along with documents. Plus they can give recommendation for further investigation. Of course, by giving reasons in support. Okay, so registrar after inspection should submit the report in writing to CG. They can give further instructions in recommendations to the CG that okay, further investigation may be required, but they have to provide the supporting okay recommendations, supporting information for that matter. So we have completed section number 206, 207, 208. We'll move on to section number 209, that is search and seizure. Search and seizure. Section number 209. So section number 209 talks about the search and seizure powers given to the registrar or the inspectors. So there can be certain circumstances where the registrar may take the search and seizure. They can do that. Okay, so we'll first note down the pointers. So now, okay, circumstances when the seizure will happen, which is given under section 2091. So whereupon information in the possession or otherwise, if the registrar or the inspector is of the opinion that, and they have the reason to believe that a company or KMP or any director, auditor, company secretary in practice uh, has, or after obtaining order of the special court, they may enter with such assistance as may be required and search the place or places where the books are kept, okay, and they can take into custody the documents or the extras thereof. So they have the power of seizure, which is given under section 209 subsection 2, which says that the original, the period of seizure can be there for 180 days. Okay, so what will be the period of seizure? Maximum 180 days. The books and papers may be called by the registrar or inspector for further period of 180 days by an order in writing. Okay, so if there is the order in writing, they can further, okay, keep it for further period of 180 days. Taking copies, placing in identification marks, all these powers are again given under section 2092, which says that the registrar or inspector may, before returning such books or papers, take copies of or extracts from them or place identification marks on them or any part thereof, or deal with the same in the other manner as they may fit comfortable or necessary. And all the powers are given under the CRPC, that is Criminal Procedure Code, relating to the seizure, okay, will be given to the registrar as well. Registrar or inspector relating to the search seizure will be applicable for every search and seizure under this section. So these are the powers given to the registrar and inspector for conducting search and seizure of the documents or information. And then it will happen investigation into affairs of company. Investigation into affairs of company, section 210. So here it is given investigation in the opinion of CG investigation on the order of court or tribunal appointment of inspectors. So the first subsection of section 2 not 210 subsection 1 talks about investigation in the opinion of the central government. Okay, so it is given under section 210 subsection 1. So where the CG is of the opinion that it is necessary to investigate into the affairs of the company on receipt of the report from registrar or inspector under section 208, which we have already discussed over here. Okay, after receipt of the report, the or on the intimation of the special resolution. So when investigation in the opinion of the central government will happen, there can be three different ways. Okay, so we can talk about that. On the receipt of a report under section 208. Second criteria is on intimation of a special resolution passed by the company. On special resolution passed by company, and then in public interest. So in this particular last, okay, wide powers are given to the central government. Okay, on the receipt of the report under section 208 in the public interest, or on the special resolution passed by the company. In these three circumstances, investigation in the opinion of the central government can be conducted. So it may order an investigation into the affairs of the company. So where an order has been passed by the court or tribunal in the proceedings before it that the affairs of the company are ought to be investigated, then the CG shall order an investigation. So CG can give the order of investigation in this particular criteria as well, which is given under section 210 subsection 2. Then to conduct the investigation, CG may appoint one or more inspectors to investigate into the matter. Appointment of inspectors. For what reason? To conduct investigation. So here we can say CG may appoint or inspectors to conduct investigation and to report thereon. As CG may direct. So wide powers are given to the CG, to direct the investigation, okay, into the affairs of the company. I hope you have understood from section number 206 to 210. Please make a note of all these points if you really want to. So we have started with 206. So report on inspection made. Search and seizure. And then investigation into the affairs of the company. I will talk about establishment of one body, establishment of serious fraud investigation office. The body name is SFIO. The provisions are given under section 211. So it talks about investigation of SFIO. The CG, who can appoint? Okay, CG by notification can establish this particular body to investigate frauds relating to the company. So first of all, okay, why CG will appoint this body? CG may establish, you can say, SFIO to investigate frauds relating to company. Then it talks about composition of SFIO. So composition of the SFIO, it basically headed by director, headed by director, and consist of such number of members, such number of, you can say, experts from different fields. As appointed by CG. So different fields like banking, corporate affairs, taxation, forensic audit, capital market, law, investigation, cyber forensics, etc. Appointment of director, who shall be an officer not below the rank of joint secretary. Okay. Appointment of experts, expert officers and employees. Appointment of and employees. CG will decide the terms and conditions as may be prescribed. So this is SFIO, establishment of SFIO. An investigation into the affairs of the company by SFIO is given under section 212. Investigation into affairs of company by SFIO. Section 212. Okay. So under section 212, how the SFIO will conduct the investigation, all those particular provisions are given. So basically central government consider it necessary to investigate, may order or assign its investigation to SFIO. Okay, on receipt of the report on registrar. So how it will happen? Okay, so CG may order. Okay, CG may order CG may, or you can say may by order assign investigation to SFIO, and after assigning that investigation to SFIO, कब investigation हो सकता है? Okay, on receipt of report, you can say on receipt of report under section 208, then special resolution passed by company, then in public interest, or on request from any department of CG, on request of any department of CGHG. So by these bodies SFIO may conduct the investigation. Okay, after taking up the assignment, on receipt of such order, SFIO may designate inspectors. So the investigation part will go to the SFIO. It may so happen investigation is pending. If investigation is pending, okay, then it will be transferred to SFIO. It will be transferred to SFIO, all the documents and records. Okay, after that, I can just put over here SFIO will conduct investigation and submit a report to CG. Investigating officer shall have powers of inspector under section 217. Company and its officers should assist SFIO for the investigation purpose. SFIO may arrest guilty person. So wide powers are given to SFIO. Concerned we can say concerned officer concerned officer should submit report to SFIO then every person arrested shall within 24 hours be taken to judicial magistrate or metropolitan magistrate SFIO should submit interim report or investigation report to CG. And after that, CG may order SFIO to initiate prosecution against company and its officers as well as employees. So these are the various powers given to SFIO regarding investigation. So CG may order us or by order assign the investigation to SFIO which is pending also. Okay, on the receipt of the report of the under 208 special resolution passed by the company in the public interest or on the request of any department of CG or SG. So in these four criterias, okay, CG may assign that particular task to SFIO. So on receipt of such order, SFIO will designate the inspectors. If the investigation is pending, it will transfer all the papers, records in his possession, okay, to SFIO. Then after doing that, SFIO will conduct investigation and submit the report to the CG. Investigation officers will have all the powers of the inspector under section 217. Company and its officers should assist SFIO. Concerned officer of the SFIO may arrest guilty person. It should submit the report to SFIO immediately, and every arrested person shall be taken to the judicial magistrate or the metropolitan magistrate, okay, within 24 hours. SFIO should submit the report, okay, interim investigation report, okay, to the CG, and CG may order SFIO to initiate prosecution against the company and its officers. So this is the way, okay, the powers are defined for the SFIO under section 212. Okay, so there are some investigative powers which are given to investigation into companies' affairs in other cases given under section 213. So cognizance of offence can be taken by tribunal. So if it is made by not less than 100 members or members holding not less than 1/10 of the total voting powers, okay, in the case of company having share capital, or not less than 1/5 of the persons on the company's register of members, so it may give the cognizance by the tribunal, and the order by the tribunal can also be made. If it is conducted to defraud the creditors, persons concerned in the formation of the management of its affairs have been guilty of fraud, misfeasance or other misconduct, so it may order, and the guilty person can be punished under 447. So it talks about cognizance of offense by tribunal, then order by tribunal, then punishment in case of guilty. Punishment in case of guilty as per section 447. So here we have completed the important parts relating to the inquiry, investigation and uh, inspection. So establishment of SFIO we have studied under section 211. Please make a note of all these points if you want. Then we studied about the investigation into affairs of the company by SFIO, the detailed procedure. So investigation into company's affairs in other cases. Section 213. So cognizance can also be taken by the tribunal, order can be passed by the tribunal and punishment in case of guilty as per section 447. So students, today in this session we have discussed about inspection, inquiry and investigation provisions which are given under chapter 14 of the Companies Act 206 to 229, but we have covered the most important provisions of it from section 206 to 213. I hope you have understood all these provisions very well. So please do watch this video, read the corresponding notes and the provisions from the Bare Act and the book, and in the next session we will again meet with a new topic of the company law. Till then, goodbye. Thank you so much.